So we'll proceed with the Town of Burrillville's motion.
Madam Chair, do you need to approve that motion? I know everyone's in agreement, but...
I believe she'll do it at the open meeting.
Oh. Understood.
Thank you, Chairperson. This is the town's motion to reject the PUC advisory opinion dated September 12, 2016. There are two reasons why the town urges this board to reject the September 12, 2016 advisory opinion of the PUC issued by former PUC Commissioner DeSimone. First, the advisory opinion of former Commissioner DeSimone is legally invalid because under RIGL 39-1-8, at least two commissioners are needed to establish a quorum for the PUC to transact any business. That's the term used in this statute, transact any business. It's as broad a term as you could have. Second, the advisory opinion is factually stale in light of many subsequent events which have occurred in the electricity market at a fast and furious pace in the 2+ years since the opinion was issued on September 12, 2016. The subsequent events demonstrate that CREC is not needed. Under RIGL 42-98-11(c), this board is required to decide if it is going to, quote, accept, reject, or modify, quote, the PUC opinion. And in fact, all advisory opinions tended to this board. We respectfully submit that, due to its legal and factual infirmities, this board should reject the PUC advisory opinion. I would also like to make it crystal clear that the town is asking only that the advisory opinion of the PUC be rejected. As for the testimony, evidence, and arguments that were presented in that docket, the town submits that all such evidence should be considered by this board, together with all other testimony, evidence, and arguments that are presented directly to this board on these crucial issues of need, cost, and alternatives. We submit that this board should independently evaluate all such testimony, evidence, and arguments, and come to its own conclusions regarding the matters of need, cost, and alternatives. Now, the first reason for the rejection of the advisory opinion is because the opinion is legally invalid. When the PUC opened docket 4609 in March of 2016, Chairperson Curran and Commissioner Gold both appropriately recused themselves, leaving only former Commissioner DeSimone to handle the board's request for an advisory opinion. It was also perfectly appropriate for Commissioner DeSimone, as a single commissioner, to preside over the PUC evidentiary hearings held here in July of 2016. That's because even though 39-1-8 and PUC Rule 1.2d require at least a two-commissioner quorum for, quote, the transaction of any business, quote, there is a limited exception in 39-1-11 that states that, quote, one commissioner shall constitute a quorum at all hearings. This allows for a single commissioner to preside over a hearing, but not to make any decisions. Therefore, a single commissioner can legally conduct an evidentiary hearing, and the conducting of the hearing was perfectly fine. We are not challenging that. The issuance of an advisory opinion, however, is different. At a minimum, it constitutes the, quote, transaction of any business, quote, and therefore requires at least a two-commissioner quorum. EFSB Rule 1.16(a), which, as you know, these rules have the force and effect of law, also states that, quote, advisory opinions, omissions, are interlocutory decisions, period, end quote. 39-1-11 expressly states that, quote, a majority of the commission shall be required for the rendering of a decision, end quote. Doesn't say final decision, doesn't say interlocutory decision, it simply uses the broad term decision. Therefore, we submit that the rendering of an advisory opinion constitutes both the transaction of business and the rendering of a decision. Therefore, under 39-1-8 and 39-1-11, at least two commissioners were required to render an advisory opinion. A virtually identical situation presented itself in EFSB docket SP-2008-02, which was the Rhode Island Reliability Project, and its accompanying PUC docket 4029. In docket 4029, the PUC chair recused himself, and a second commissioner was unavailable due to an injury. That left only one commissioner. Instead of rendering an invalid advisory opinion, the Commission directed PUC legal counsel to notify this board, and it did so in a letter dated April 8, 2009, that the PUC was, quote, unable to produce a quorum for the purposes of rendering an advisory opinion, end quote. PUC legal counsel also stated in that letter, quote, as a result, the Commission is closing its docket 4029 and transferring all filings made within the docket to the Energy Facilities Siting Board for its ultimate review of the need and cost considerations, end quote. A copy of that letter is attached to the town's motion. What the PUC did in docket 4029 is exactly what the PUC should have done here in docket 4609. But even though the town objected verbally and in writing, former Commissioner DeSimone went ahead without the required quorum and issued a legally invalid advisory opinion. If this board does not reject the advisory opinion and relies on it in any way in issuing a license for CREC, it is the town's firm belief that this board would be committing a serious error of law. Now, the second reason the town urges this board to reject the advisory opinion is because that opinion, which is now over 2 years old, is outdated, stale, and no longer relevant to current market conditions. Many significant events have rapidly and continuously occurred in the electricity market in the last 2 years. Those events have rendered the analysis and conclusions of the PUC opinion regarding need, cost, and alternatives no longer valid under these current market conditions. RIGL 42-98-2 and 42-98-11 requires that this board cannot grant a license for CREC unless this board finds, among other things, that Invenergy has met its burden of proof and shown by competent evidence, 1, that CREC is, quote, necessary to meet the needs of the state and or region for energy, quote, 2, that CREC is, quote, cost justified, quote, and 3, that Invenergy has proven that there are no, quote, cost-effective efficiency and conservation opportunities, quote, that, quote, provide an appropriate alternative, quote, to CREC. Of course, this board also cannot issue such a license unless it finds that Invenergy has also proven that CREC, quote, will not cause unacceptable harm to the environment and will enhance the socioeconomic fabric of the state, end quote. But the environmental and socioeconomic issues were not before the PUC, and we don't need to address them. New events in the New England energy market, as I stated, are happening at a fast and furious pace. These events render former Commissioner DeSimone's advisory opinion stale and outdated. These events include, but are not limited to, the following. 1. 4 weeks ago, Unit 1 CSO was recommended to the FERC for termination by ISO. 2. Unit 2 has failed to obtain a CSO for 3 successive annual auctions, forward capacity auctions 10, 11, and 12. And just 4 weeks ago, Unit 2 was disqualified from participating in FCA 13. 3. Existing and planned energy efficiency and behind-the-meter photovoltaic resources have significantly reduced the peak load needs of the region in every year since 2015, with the 2018 ISO forecast indicating about a 3,000 megawatt reduction in net peak load requirements for the year 2024 as compared to its 2015 forecast. 4. Invenergy has twice been able to have its 485 megawatt CSO for Unit 1 met by an existing electric generator in this region through the annual reconfiguration auctions conducted by ISO. 5. About 2,000 megawatts of solar has recently been installed in the New England region. 6. Massachusetts recently selected New England Clean Energy Connect to provide approximately 1,000 megawatts of inexpensive baseload renewable energy. The levelized price is only about 5.9 cents per kilowatt hour. 7. Massachusetts, Rhode Island, and Connecticut have recently selected Vineyard Wind and Deepwater Wind to develop 1,400 megawatts of inexpensive offshore wind. The Vineyard Wind pricing is a levelized price of only approximately 6.5 cents per kilowatt hour. 8. 2 months ago, Massachusetts passed a new law authorizing the solicitation of an additional 1,600 megawatts of offshore wind. 9. Retirements in the forward capacity auctions held in 2016 to 2018 after Commissioner DeSimone issued his advisory opinion have resulted in only about 1,320 megawatts of retirement in our region. But there are currently over 2,900 megawatts of sponsored policy resources seeking capacity supply obligations in FCA 13. This is significantly in excess of the retirements that need to be replaced. 10. Just 2 days ago, ISO announced that it has submitted proposed rule revisions to FERC that would allow batteries and other energy storage technologies to more fully participate in the wholesale energy markets, including the real-time energy market. 11. CREC's lack of a CSO for both Unit 1 and Unit 2 now make its filing strikingly similar to the 2016 filing by NTE Connecticut. This was filed after Commissioner DeSimone issued its advisory opinion. NTE sought a certificate of public need from the Connecticut Siting Council for the Killingly Energy Center. It would have been a proposed 550 megawatt dual-fueled combined cycle generating facility similar to CREC. It would have been built in Killingly, Connecticut. In its opinion denying the requested certificate, issued after Commissioner DeSimone issued his advisory opinion, the Council pointed specifically to NTE's lack of a CSO for the Killingly Energy Center as evidence that the proposed facility was not needed. In its May 11, 2017 opinion, the Council ruled in pertinent part, quote, "The Council finds and determines that the proposed facility is not necessary for the reliability of the energy power supply of the state or for a competitive market for electricity at this time." End quote. That's at page 11 of the opinion. The testimonies of Glenn C. Walker filed by the town also demonstrate in much more detail than I have outlined here how the PUC 2016 advisory opinion is stale and cannot and should not be relied upon by this board in this docket. Now, Invenergy claims that under the outdated and revised procedural schedule, our motion was filed too late. But no one has been prejudiced by this motion. In fact, it's the opposite. Under the current procedural schedule, the PUC advisory opinion is not scheduled to be presented to this board until December 6th at the earliest. We could have simply waited until the advisory opinion was presented to the board and then entered our objection to this board accepting the opinion. But we felt that filing this motion well in advance of the December 6th hearing would give all parties and this board plenty of time to consider whether the advisory opinion should be accepted or rejected, as we are doing here now. Moreover, the Rhode Island Supreme Court has made it clear that whether an administrative body such as the PUC had jurisdiction to sit and decide a matter may be raised at any time and cannot legally be waived. That's the DeMarco versus Travelers Insurance case, 102 Atlantic 3rd, 616 at 621, a 2014 decision of the Rhode Island Supreme Court. Therefore, the town respectfully submits that this board should reject the September 12, 2016 advisory opinion of the PUC because it is both legally invalid and factually stale. Instead, the town suggests that the EFSB should independently develop its own evidentiary record and findings on the crucial issues of need, cost, and alternatives. Thank you, and I would be happy to answer any questions.
Thank you. We're going to take a brief recess.
CLF supports Burrowville's motion and would like to address two specific matters raised by Invenergy in Invenergy's filings in opposition to Burrowville's motion. The first of the two matters that CLF would like to address is the matter of timeliness that Invenergy raised in its September 26th filing. Second, the matter of ratepayer impacts that Invenergy addressed in its October 5th filing. First, on the matter of the timeliness of Invenergy's motion, of Burrowville's motion, I apologize. Invenergy says that the motion is untimely because it was not filed before the commencement of the final hearing. Invenergy says on page 1 of its September 26 filing, quote, "The town's motion should be denied because it was filed out of time," unquote. On page 2, Invenergy says, "As the town's motion was filed far too late, it should be denied," end of quote. The short answer to Invenergy's assertions is that the two major events that make the PUC decision stale and outdated had not occurred when the final hearing in this case started. Those two key signal events occurred on September 20th when the ISO made its filing with FERC to discontinue the capacity supply obligation on Turbine 1. That was, of course, the first time in the history of the ISO that it has ever sought to terminate a CSO on a generator. And the second event happened on September 28th with the issuance of the QDN, the qualification determination notification, saying that Invenergy's Turbine 2 is ineligible for the next forward capacity auction. So the short answer to Invenergy's assertion that Burrowville's motion is untimely is that the signal events that lead to the motion, lead to the PUC opinion being stale and out of date, didn't happen until September 20th and 28th. But there's broader context here which is also important. The first part of the context here is that Invenergy wants to freeze the EFSB's review in some arbitrary past time and not take account of the fact that energy markets are changing and new facts need to come into evidence. Since this docket was opened, there have been 3 separate CELT, C-E-L-T, capacity, energy, loads, and transmission. 3 separate CELT reports issued by the ISO. 2 of those, since the PUC rendered its advisory opinion, 1 of those since this final hearing began. There have been 3 separate forward capacity auctions since this docket was open. There are going to be 4 of them before this docket is over. 2 of them occurred since the PUC issued its advisory opinion. 1 of them occurred since the final hearing has been on. There have been 3 separate QDNs, qualification determination notifications issued by the ISO. 1 of them since the final hearing has been on. There have been many reconfiguration auctions, not only annual reconfiguration auctions run by the ISO, but monthly reconfiguration auctions. All of those things, the CELT reports, the auction results, the QDNs, the ARA results, all of them are probative of the issue of whether or not this plant is needed, and Invenergy's effort to freeze consideration at some arbitrary previous time should not be accepted. There's a second aspect of context on timeliness that's also important. As you know, day before yesterday, Monday, October 29th, with the 3-year anniversary, of Invenergy's filing with the EFSB that opened this docket. And many of the worst delays that have happened in this case have been on account of Invenergy's dishonesty with the EFSB and the parties, and ham-fistedness in handling the application. For example, the issue of water. On January 12, 2016, we had the preliminary hearing in this docket, and Invenergy presented a PowerPoint slideshow at the preliminary hearing in this room on January 12, 2016. On slide 34, Invenergy told the EFSB, quote, I'm not paraphrasing, quote, the project will obtain water from Pasco Utility District, unquote. Invenergy did not say might obtain water. Invenergy did not say we hope to maybe possibly obtain water. Invenergy said on slide 34 the project will obtain water from the Pasco Utility District. The application, section 6.2.3.1, entitled Water Sources, on page 46, paragraph 3, said, quote, water from Pasco Utility District's well will be treated at the wellhead, unquote. Mr. Nyland's testimony here on January 12, 2016 at the preliminary hearing is in the transcript of that day, page 141, lines 17 to 20. Invenergy failed to disclose to the EFSB that it did not have a firm contract with the Pasco Utility District for water. Invenergy failed to disclose to the EFSB at that time that all it had was a non-binding letter of intent to get water. But Invenergy, not to put too fine a point on it, is represented here by 7 lawyers from 3 firms in 2 states, and they know the difference between a binding contract and a non-binding letter of intent, because they all studied that in first-year contracts. The application, even if the lawyers didn't know, the application, section 1, page 1, tells us that Invenergy is a sophisticated developer of projects on 2 continents, totaling over 9,000 megawatts of conventional and renewable projects. The EFSB was forced to issue Order 103, suspending the docket for months while Invenergy belatedly looked for a secure source of water that it should have had before it filed the application. On November 27, 2017, in this hearing, the transcript, page 91, lines 8 to 23, Director Coit said, quote, I think the delays in the permitting process are in relation to the way it's been handled. It was a full year after the application was submitted that we ended up, without your objection, suspending. We suspended the process because you didn't have a water plan. So just for the record, I do not think the delays in the permitting process are about the way the board has handled things, but about the way you've handled things. Then there was the delay when Invenergy did not inform the EFSB or the parties of the disqualification of Turbine 2 from FCA 12. That happened a year ago. Invenergy learned about that in September of 2017. And Invenergy did not inform the board until November of 2017. In the meantime, Invenergy had its own expert prepare supplemental testimony that said this doesn't mean anything at all, and there was delay while the other parties got an equal shot preparing separate expert testimony about what that meant. I incorporate by reference Director Coit's comment that the delays in the permitting process are because of what Invenergy has handled it. Then there was a water contract that Invenergy entered into with one faction of the feuding Narragansett Indian tribe. We had motions to intervene from competing factions of the tribe. We had a motion to intervene from Charlestown, who thought that their water was implicated. We had putative injunctions from putative Indian boards that most of us never knew existed, enjoining the EFSB from looking at the intervention papers of the factions of the Indian tribe. I will observe that there's no evidence in the record that Invenergy knew about the long-standing governance dispute between factions of the Narragansett tribe when they brought that water contract with the tribe to the EFSB. That was again apparently ignorance on Invenergy's part, not malice, but it does show a project that's not ready for prime time. And then one of the largest delays was the FERC cases a year ago. The two FERC cases, ER 18-349 and EL 18-31, in which Invenergy clandestinely, without telling the EFSB, sought to transfer $164 million in interconnection costs away from Invenergy and to ratepayers, in direct violation of the long-standing FERC-approved ISO tariff. CLF was forced to inform the EFSB of those lawsuits on November 27, 2017. Mr. Nyland, in a letter on December 1st, sought to, quote, clarify his comments, unquote, but failed to disclose the pendency of the lawsuits. And so the pendency of those two lawsuits had to be disclosed to the EFSB in a letter from CLF dated December 11, 2017. And in that letter, we quoted to the EFSB what was said about the lawsuits to FERC by NESCO, that's NESCOE, the New England States Committee on Electricity. It's a consortium of all the New England states. I believe that the gentleman who sits behind me at some of these hearings, Nick Ucci, is the Rhode Island representative to NESCO. NESCO said about Invenergy's effort to clandestinely transfer $164 million in expenses to ratepayers, quote, if granted, Invenergy's complaint would undo the long-standing cost structure between interconnection customers and transmission customers, fundamentally altering this transmission rate framework and unjustly and unreasonably shifting costs from generators to consumers. The cost shift to consumers that Invenergy seeks to accomplish, potentially hundreds of millions of dollars, just related to this complaint alone, and the likelihood of hundreds of millions of dollars more from future interconnecting generators, is both sweeping and unfounded, unquote. The Connecticut Office of Consumer Counsel, Connecticut's statutory ratepayer advocate, like our Division of Public Utilities and Carriers, said, Invenergy claims that certain costs and expenses associated with network upgrades are unjustly assigned to interconnection customers. The result under Invenergy's proposed approach would be a shift of such costs onto the end users, represented by Connecticut Office of Consumer Counsel. Connecticut electric customers are therefore directly affected by the outcome of this proceeding. And the New England Power Pool, NEPOOL, N-E-P-O-O-L, NEPOOL, the association of all the big energy producers in New England and others. Invenergy is a member of NEPOOL. It was represented there until recently by Alex Ma. NEPOOL had to oppose its own member, Invenergy, before FERC. NEPOOL said, Invenergy seeks to have the commission, that is FERC, solve its, Invenergy's, payment obligation problem by changing well-established rules that all other load and generation interests have relied upon for almost 20 years. Invenergy now seeks involuntary rule changes that would result in shifting its cost responsibilities onto the backs of transmission customers and give Invenergy a windfall for costs that presumably were already factored in to its FCA 10 forward capacity auction 10 bid. I incorporate again by reference Director Coit's comments about delays here. We had to have a big delay pending those FERC cases to see how they were resolved, and finally Mr. Blazer stepped in and Invenergy withdrew those cases completely. The short answer to Invenergy's suggestion that Burrill's motion is untimely, the short answer is that the key events didn't happen until September 20th and 28th, and the motion really couldn't have been made earlier. But the context here is crucially important, and that is, yes, we have had delays. We've had delays over and over and over again on account of missteps, mistakes, and misrepresentations made by Invenergy. And in that context, Invenergy should not be allowed to say that the EFSB cannot take account of new events, new circumstances, new facts in the energy market. The central point in Burrill's motion, or at least one of the two central points, is the PUC opinion is old, outdated, and stale. And a large part of the reason why that is true has to do with delays that have been caused by Invenergy. The second matter I want to address is the statement in Invenergy's October 5th filing on page 8 that says, quote, this is in boldface type near the bottom of the page, quote, the cost justification analysis in the advisory opinion remains valid. That assertion, respectfully, that the cost justification analysis in this PUC advisory opinion remains valid, is not true. Almost all of the ratepayer impacts, the ratepayer savings, the ratepayer benefits that were described at the PUC and described in this room at the preliminary hearing on January 12, 2016, came from the capacity side of the market, from having a capacity supply obligation, and not from the energy side of the market, from the sale of electricity. At the preliminary hearing of this docket in this room, in Invenergy's nice, colorful PowerPoint presentation, Invenergy said $280 million in ratepayer savings. That appears twice, once on slide 21 with the figure $280 million, and again on slide 24, where Invenergy shows that almost all, not 100%, but pretty close to all of those savings came from the capacity side, from having a capacity supply obligation, which it doesn't have now. And in fact, that's what was stated in the PUC docket by the joint witness of the Office of Energy Resources and the division, Seth Parker, and by the witness of Invenergy, John Nyland. And I have the testimony here, and I will get to that in just a moment. The bottom line is that with no CSO today, those ratepayer benefits described to the EFSB and to the PUC essentially disappear. We'll start with Seth Parker's testimony. This was the joint witness of OER, Office of Energy Resources, and the division. For purposes of the stenographic record, there are in Mr. Parker's testimony some abbreviations. PA is the consulting company that Invenergy's witness Ryan Hardy works for. FCM is Forward Capacity Market, and FCA is Forward Capacity Auction, and you have FCA 10, FCA 11, and so forth. Those are denominated with hyphens. So here's Mr. Parker's cross-examination by me. The date is July 27th, 2016, beginning on page 31, line 23. Question from Mr. Elmer. Let me direct your attention to page 35. The question at line 22 is, quote, were you able to analyze PA's estimated capacity price reduction for FCA's 11 to 13? Your answer at line 23, please. Mr. Parker's answer at line 4 of page 32. No, I could not without without detailed modeling data from PA and ISO New England's parameters for those future auctions that have not yet been established. Question. And your opinion of the effect of Invenergy's presence in the auction, on capacity clearing prices for FCA 10 for Rhode Island ratepayers is 50 to 75% lower than Invenergy's estimate. Is that correct? Answer. I wouldn't couch it in such precise terms. I would rather find my exact words in the testimony. Question. It starts at page 35, line 19, starting with the net effect of my analysis. Could you read that sentence into the record, please? Answer by Mr. Parker. Quote, the net effect, and this is an internal quote, so he's reading from his analysis. The net effect of my analysis is that the actual wholesale capacity benefits for Rhode Island consumers for FCA 10 is likely around 1/4 to 1/2 of PA's estimate. Question on page 33, line 13. So, page 39 of your pre-filed testimony. The question at line 13 is, did you try to estimate the significance of consumer savings due to CREC, C-R-E-C? And in part, your answer says on line 14, yes, in a very rough fashion. And then you continue on line 18, when adjusted to reflect PA's exaggerated wholesale capacity price savings and the likely growth in the dollar value of electricity sales as higher gas prices drive up wholesale energy prices, the percentage savings for Rhode Island consumers will be small but meaningful. Question, did I read that correctly? Mr. Parker's answer, yes. All the parties at the PUC stipulated that the capacity price benefits to ratepayers would be small, as Mr. Parker said, small but meaningful, and the chart that you have in front of you shows why that's true. And with apologies to Ms. Brady, because you weren't here during the opening statements, I distributed a copy of this chart then. But this shows exactly why that $280 million figure of ratepayer benefits, ratepayer impacts that was presented here by Invenergy is no longer true. Look at FCA 9 in 2015. Invenergy was counting on a capacity clearing price of $17.73, and Invenergy was counting on 2 turbines clearing 1,000 megawatt capacity supply obligation. Well, what happened in the next auction? Between FCA 9 and FCA 10, we had the final, the preliminary hearing here. And then after the preliminary hearing, the ISO ran FCA 10, and what happened? 2 things happened. First, the clearing price crashed by 61%, from $17.73 to $7.03. And Invenergy cleared 1 turbine, not 2. The ratepayer impact, almost all of the ratepayer impacts that Invenergy has told the EFSB about and the PUC about came from the capacity supply side, not the energy side. And that's why Seth Parker said, after the clearing price crashed, after Invenergy failed to clear a 2nd turbine, after that clearing price went down 61%, Seth Parker said, yeah, there's some savings, they're small but meaningful, and those small savings disappeared when Invenergy's CSO disappeared on September 20th. Not only that,
Could I interrupt? And I'm so sorry. I just want to know, we said we'd start the open meeting at 11:45. Sorry to interrupt. What I'd like to do is have Mr. Elmer finish, and then Mr. Blazer also speak to this motion, and then take a break, maybe 20 minutes, and then start the open meeting. So I just want to put people on notice. I don't know how, can we leave it up in the air when the open meeting starts? Okay, so.
Director Coy, I can assure you I will have nowhere near as much as Mr. Elmer does.
Okay, so 12:30, we'll have the open meeting start at 12:30, we'll finish up and take a break until then, and proceed.
so Mr. Hardy's testimony in this room at the preliminary hearing was that most of the ratepayer benefits come from the capacity side, not from the energy side, and those benefits, of course, disappeared when the CSO disappeared. So the statement on page 8 of Invenergy's October 5th filing is wrong, that, quote, the cost justification analysis in the advisory opinion remains valid. But there's another important point here, and that is that Invenergy, when Invenergy made its October 5th filing, it knew that the statement it was making on page 8 was factually incorrect. We now have John Nyland's cross-examination before the PUC on July 25th, 2016. And we're reading from page 63, starting at line 13. Examination by Mr. Elmer. Question. Mr. Nyland, on Thursday evening, March 31st, you spoke at a hearing of the Energy Facility Siting Board at Burrillville High School. Is that correct? Answer at line 17. Yes. We're now jumping to page 64, line 17. You said in the transcript of that day, page 16, lines 8 to 11, quote, talking about ratepayer savings, the analyses that we've done looks at what happens to the cost of power to the region when you put in a unit like this. Then continuing on line 15, you say, I'm speaking to Mr. Nyland, quote, that's really what the $280 million number represents. Do you recall that? Mr. Nyland's answer on page 65, line 1, yes, I do. Question. And that number wasn't correct, was it? Answer, page 65, line 3, yeah. Oh, and by the way, I am not reading this now in order to indicate that Invenergy misstated the benefits in the Burrillville High School on March 31st in front of an audience of 700 people and the full membership of the EFSB. I am not reading this for that purpose. I'm reading this for the purpose to show that Mr. Nyland knew that with these auction results, of the capacity clearing price crashing 61% and one turbine clearing not two, Mr. Nyland knew that the ratepayer benefits were largely changed, and of course they would completely disappear when the CSO disappears. Mr. Nyland said, so my question was, that number wasn't correct, was it? And Mr. Nyland says, yeah. At that time, we knew the results of the capacity auction. The previous study that we had done prior to the capacity auction, that's where the $280 million number came from. We were in the process of redoing our analysis, and the analysis is quite complex, and I'm sure Mr. Hardy will be able to explain later on, we hadn't completed the results of that yet. The short of it is that the ratepayer benefits that were given to this EFSB at the preliminary hearing on January 12, 2016, on slide 21 and slide 24 of Invenergy's PowerPoint slides, shows almost all of the benefits to ratepayers coming from the capacity market. And the way that works is once a unit like Invenergy or any other unit clears in a forward capacity auction, it gets entered at zero as a price taker in every future auction. And that fact of being entered as a price taker in future auctions drives down the clearing price and sends benefits to ratepayers. The statement that Invenergy makes, don't reject the PUC opinion, because the cost justification analysis in the PUC opinion, that's still valid today. It's not true. The cost justification analysis that the PUC relied on, just like Ryan Hardy's slides to the EFSB, slide 21 and 24 relied on, just like OER and the division's witness Seth Parker relied on. As Seth Parker said, those ratepayer benefits were small after Invenergy cleared one turbine, not two. And today, they are virtually non-existent in the wake of the CSO being terminated. Burrillville's motion is not untimely, and its argument that the PUC advisory opinion is stale is basically correct, and Invenergy's argument that other parts other than need, like the cost justification, support the PUC advisory opinion are not correct. Thank you.
Thank you, Director. I won't spend much time on Mr. McElroy's assertion that the opinion is legally invalid because of the single commissioner issue. As this board knows, that issue was raised before the PUC. It was addressed by the PUC in the opinion that was issued in September of 2016. I will quote, this is from page 4. there is a clear difference between providing an advisory opinion and rendering a decision that is binding upon parties or the public and is subject to appeal. In fact, the Energy Facility Siting Act makes that distinction when it states, quote, advisory opinions issued by agencies designated under section 4298-9 shall not be considered as final decisions of the agencies making the opinions and shall not be subject to judicial review, close quote. And that's based on the express language of 4298-10B, which, as the advisory opinion states, says advisory opinions issued by agencies designated under 4298-9, and as you know, under -9, the PUC is specifically delegated with the responsibility of issuing an opinion on need, shall not be considered as final decisions of the agencies making the opinions, and shall not be subject to judicial review under section 4235-15 or any other provision of the general laws. So why is that relevant? Because number one, since it is not a final decision, as the PUC itself stated in its opinion, it was authorized to issue an opinion with one commissioner. But let's assume for the sake of argument that that's wrong and that by some stroke of a pen 4298-10 doesn't exist. That doesn't solve either the town or CLF's problem, since the CLF joined in this motion. If this town is correct, if the town is correct, and the PUC advisory opinion in fact constituted a decision, which clearly doesn't under the statute, but let's assume that it does, as we point out in our response to this motion, under RIGL 39-5-1, anyone objecting to this issue was required to file for certiorari review within 7 days of the date of that decision. The decision was rendered September 12, 2016. That means an appeal had to be filed by no later than September 19, 2016. That never happened. Again, we know why it never happened, because this isn't a final decision, but again, we're speculating here on the assumption that 4298-10 doesn't exist. So if the town is right, then the town's motion is time barred, as we point out in our response. Its claim is subject to res judicata, and its assertion in this proceeding constitutes an improper collateral attack. So clearly this opinion is not legally invalid. At least that portion of Mr. McElroy's argument that assails the validity of a single commissioner opinion is legally invalid. Turning to the substance of the motion, and I'm probably stating the obvious here, but as you know, oddly enough, given all the arguments we've heard so far, this is the only one of the three today that is actually contested, despite all the arguments on the other two. Factually, my notes here say factually stale, no longer relevant to current market conditions. That was Mr. McElroy's statement. I must say that rejecting this opinion at this point is in fact completely inconsistent with the agreement the parties just reached to agree to the entire PUC, to agree to this board taking administrative notice of the entire PUC record. And I'll remind you, the agreement I had reached initially with Mr. Elmer was just about the post-hearing briefs. It was Mr. McElroy who suggested have the board take judicial notice or administrative notice of the entire record. If in fact this opinion is no longer relevant, then the basis for this opinion, which is that record that we've now agreed this board should take administrative notice of, is also irrelevant. And that again is inconsistent with the agreement we've reached. So they can't have it both ways. And we all know this record and this opinion remain relevant, highly relevant and probative. I'll get to the the specific reasons for that in a moment. I want to address very briefly Mr. Elmer's testimony. And I say that very advisedly and very intentionally. What he has been doing here today is not arguing, it is testifying. I don't intend to do that. We have a hearing schedule here. The witnesses on need are scheduled for December 6th and several days in January. Mr. Elmer is not identified as one of those witnesses. We know who they are, and I'm not trying to be flippant here. I think it's an important distinction that he consistently testifies of what he claims to be the facts and the law. I might remind this board that Dr. Roberts learned the folly of listening to Mr. Elmer's representations about the facts and the law when he testified here last month. But with that being said, just as an example, Mr. Elmer said this morning, and he said it multiple times before in media outlets, that this is the first time that ISO New England has ever sought to terminate a capacity resource. Again, I don't intend to testify here, but I believe that the record will ultimately reflect, through some witness, not through an attorney, that in fact, since 2010 through January of this year, 66 different capacity resources have in fact been terminated. The most recent one being January of this year. So again, I'm not trying to testify, I don't intend to go down that road, but I think there is great folly, and it is inappropriate, number one, for Mr. Elmer to be testifying, and number two, for this board to be considering what is clearly testimony and not argument. So, let's go to what's really at issue here. And frankly, what's really at issue here is not whether or not you should consider the PUC record, whether or not you should consider the advisory opinion. There's a very simple issue at the heart of all of this that this board will have to determine at the conclusion of this proceeding. And that is fundamentally, how do you determine need? It's really as simple as that. What factors do you take into account? And it is with that issue in mind that I'll turn to our response to the actual substance of this motion. One of the things that was said this morning is that we are now suddenly changing our position on whether or not a capacity supply obligation is relevant to the issue of need. That is in fact not true. This is what we said at the conclusion of the PUC hearing in our post-hearing brief, which this board has now taken administrative notice of, and I'll quote. Pursuant to the Act, the board shall issue a decision granting a license only upon finding that Invenergy has shown that, quote, construction of the proposed facility is necessary to meet the needs of the state and/or region for energy of the type to be produced by the proposed facility. We're all familiar with that language. It's from 4291.1. While possessing a CSO is strong evidence of need, the Act does not require a procurement contract or a CSO as a necessary prerequisite to establish need for a new generation resource. For example, in Tiverton Power and Hope Energy, the board did not require that procurement contracts were a condition precedent to establish need. And the PUC, in its advisory opinion, didn't just agree with that proposition, but went through in great detail the 20-year history of how it had interpreted the question of need in the aftermath of the adoption of the Utility Restructuring Act. And again, with your permission, I'll quote. I'm not going to testify. These are all from the advisory opinion. Page 2. As the facility will be operated as a merchant plant by Invenergy, all of the costs and risks relative to the plant will be borne by the applicant and not by the ratepayers. Pages 4 to 5, this is what I was talking about a few moments ago. This is the fourth advisory opinion issued by the Commission since the passage of the Utility Restructuring Act in 1996. Skipping a few words. Since the passage of the URA, in conducting its analysis of need, the Commission has noted that the, quote, heightened level of scrutiny for determining need, once absolutely necessary when ratepayers alone face the cost of additional generation facilities, is no longer required. The Commission also determined that, quote, even if sufficient generation exists, replacement of inefficient old plants with clean, efficient new plants may have economic as well as environmental value. Absent a gap between supply and demand, and I'll stop there for a moment, and we need look no farther than what happened in this region after on the Labor Day weekend, when I think, as everyone knows, there was a dramatic gap between supply and demand. However, absent a gap between supply and demand, I'll go back to my quote, new plants may still be considered needed by the region. In the end, it is the market that will supply the answers in the time allowed. Similarly, the Commission has stated that in the competitive generation market, new generating units are built as merchant plants. I believe everyone here knows what merchant plants means, but merchant plant means that we're operating at the whim of the market. We don't have a supply contract, we don't have a CSO. Are built as merchant plants, where the risk of selling electricity and the cost of plant construction are placed upon private investors rather than ratepayers. Based on the findings of prior commissions, I agree that the appropriate assessment of need in this matter occurs in the context of this changed risk dynamic, away from ratepayers and toward investors. And I want to digress for a moment in the context of the discussion about prior PUC advisory opinions. Mr. McElroy mentioned this April 8, 2009 letter from Ms. Wilson-Frias, who, as we all know, is still here. Was here in September 2016, acting in the same capacity as counsel for the PUC, and at that time acting alone for Commissioner DeSimone. I won't hazard to guess why this April 8, 2009 letter was issued at that time. I will only point out that it is inconsistent with this lengthy history of opinions. I should have mentioned this when we were talking about whether or not it's a valid opinion. But it's clearly inconsistent with the Energy Facility Siting Act and with the provision on when that opinion should have been appealed. Getting back to the substance of this, however, back to the PUC opinion. Page 6. And here's really the heart of the matter, and this, because as we all know, this entire argument, the sole reason this motion was filed is because ISO has sought to terminate the CSO for Unit 1. There is no other reason for it. Page 6. The award of a capacity supply obligation by ISO NE, the regional transmission operator for the New England region, is one component in the need analysis and is evidence of need in the wholesale market in the near term. Page 8. However, obtaining a capacity supply obligation is only one component of the need analysis. While the existence of a capacity supply obligation signals a need in the short term, that should not be the only component reviewed in this matter. The PUC has a history of reviewing not just short-term need and reliability, but also longer-term needs of the region and of Rhode Island. In the EFSB's order approving the construction of the Ocean State Power Generating Facility prior to restructuring, the need analysis conducted by the PUC and accepted by the EFSB considered the need for additional energy and capacity into the next decade. This decision was rendered prior to the passage of the URA, when the risk of overinvesting was on captive ratepayers, while the forward capacity market and forward capacity auction signals whether a unit is needed for reliability in the short term. There are other factors to consider in assessing need over the longer term. Furthermore, Rhode Island General Laws 4298-9 does not limit the definition of need to short-term need. Page 10. Based on the fact that ISO New England, and let me stop there for a second. Again, one situation has not changed at all from then until now. Unit 2 didn't have a CSO then, and it doesn't have a CSO now. Page 10. Based on the fact that ISO New England has identified as a challenge to reliability the approximately 10,000 megawatts of retirements and at risk for closing of non-gas fossil fuel fire generation in New England, the entire CREC facility is needed for continued reliability in the region. Page 12, where imports of energy will be needed even with the addition of Clear River, it can only benefit the region and the state of Rhode Island consumers to have Clear River located within the southeast New England zone. Therefore, Clear River is needed within the southeast New England zone. Now, we said something else at the conclusion of the PUC hearing. Again, in the same post-hearing brief. Not having a CSO for the total 1,000 megawatts proposed by Clear River should similarly not disqualify the project. And again, this was our post-hearing brief before the advisory opinion was issued. Also, the ISO New England process is designed to allow and to encourage new projects to file for and begin the process to obtain permits and licenses before participating in future capacity auctions. I mention that now because CLF, despite the position that they now claim to adhere to, actually agrees with that concept, that you can get a permit from this body without ever having a CSO. Here's what their attorney, Mr. Elmer, said to this board on January 12, 2016, during the hearing on CLF's motion to close this docket. And that's the transcript there is pages 73 to 75. Invenergy's choice to proceed in this order, seeking a CSO before obtaining permits, is by no means the universal election of new generation assets seeking to enter the ISO New England market. And that is completely correct. It is not wrongful what they did. In fact, when you look at the history of the forward capacity auctions run by ISO New England, new generations seeking to enter the New England market have a choice to go one of two ways. And both routes, by the way, are proper. Both are done, and both have advantages and disadvantages. One route is the route that Invenergy chose to take. Go for a capacity supply obligation in the upcoming FCA test, which is going to start on February 8th, before it has its permits. The plus, and it's a big plus there, is that they stand to start receiving their stream of capacity supply payments at an earlier time. That's a stream of tens, if not hundreds of millions of dollars. He's wrong, by the way, it's nowhere near hundreds of millions, but we'll let that go for now. A material matter for a company that is looking for merchant financing for a $700 million plant. The disadvantage, of course, is that they have to post financial assurance with the ISO, bonding which they could forfeit if they don't get the permits. That is, in fact, millions of dollars. Conversely, there's a plus and minus to going the other way. And some resources do elect to go the other way. You get the permits first. The disadvantage is you delay the time when your capacity payments start flowing in order to collateralize your bank loans to build your plant. That's the downside. The upside is you have less of a risk of losing your financial assurance, the bonding under the ISO market rule. I want to be very clear. I'm still quoting him here. This isn't me. This is still Mr. Elmer talking. CLF is not saying, we are not saying that Invenergy's election was wrongful. It was not wrongful. They cite a couple of other power plants in New England, including the Footprint plant up in Salem, Massachusetts, that used the same method as Invenergy. It is not unheard of. It is not wrongful. And Mr. Elmer doubled down on those propositions on October 13, 2016, during the show cause hearing here, before your time, Ms. Brady. Page 25 to 26 of that transcript. The second thing is, I argued on January 12 that Invenergy had made the election of acquiring a capacity supply obligation from the ISO before getting its plant permitted. And I argued that Invenergy made that election and ought to be forced to live with it. The chair of the EFSB asked me correctly, was it wrongful to get a CSO from the ISO before getting permitted? Don't plants do that routinely? And the answer I gave on January 12 was, yes, it's done both ways. There are pluses and minuses both ways. Some plants elect, as Invenergy did, to acquire a CSO, capacity supply obligation, from the ISO before getting permitted. Has advantages of a stream of income, but disadvantages and the risk of not getting permitted. Other plants choose a different election. They chose to get permitted first, which lends more security and safety, they choose, to get permitted first, which lends more security and safety, but at the sacrifice of a stream of income. So it is quite clear that CLF completely agrees with the proposition that you do not need a CSO to establish need, the proposition that lies at the heart of the advisory opinion that's at issue in this hearing. Because if you needed a CSO to establish need, then Mr. Elmer's statements would be completely wrong, and we would always have to have a CSO before we could proceed forward with the permit process. And that gets us to something Mr. McElroy mentioned very briefly. The killingly administrative decision out of Connecticut. And that decision did in fact find that the facility in that proceeding was not needed because it didn't have a CSO. All we can suggest about that decision is that it's from Connecticut. And 20 years of administrative jurisprudence in this state says exactly the opposite. You do not need a CSO to establish need. That sounded quite redundant. I apologize for that. Now, apart from that, and I have to say in this context, in this motion, I have a certain sense of deja vu with respect to what CLF and the town are asking you to do. Because they asked you to do something very similar just this past April. In their motion for an express statement on the applicable cost standard. That's the other half of this advisory opinion, because it's on cost and need. Now, this is what we pointed out then in terms of what our consistent position has been throughout this process. Invenergy has noted that previous energy facility siting boards and previous PUC commissions stated that the Act's cost and need standard should be evaluated within the context of the applicable restructured electric market in the region, including Rhode Island, where the risks and costs associated with a project are borne by private entities and not passed on to ratepayers. And we actually referred to our memorandum in the PUC docket and the cases that we're all familiar with, Tiverton, Indec, Hope Energy, etc. All of those prior decisions that all stand for exactly the same thing in the aftermath of the URA. Here's also what we said. The hearing, you may recall, was on April 11th. As previously considered by past boards when rendering previous EFSB decisions, the board may consider information and evidence regarding the restructured electric market and the impact it has on the cost and need analysis in the context of this Invenergy application when determining whether Invenergy satisfied its burden under the Act. Invenergy has not and is not requesting that the EFSB ignore or disregard the Act's statutory standard for cost. That said, as previous boards and commissions have determined, the Act's standard for cost and need must be reviewed in the context of the changes to the wholesale electric market authorized by the General Assembly in the URA. And with all due respect, this is what my colleague, Mr. McElroy, said at that hearing. This is at pages 26 to 27 of the transcript from this April 11 hearing. The town supports CLF's motion, and while we are fully confident that the statutory standard will be applied by this board, there will, at some point in time, be a question of whether or not the Utility Restructuring Act either implicitly repealed or had an effect in some way on the cost standard and the need standard in the Energy Facility Siting Act. This is what we're heading down the road in the presentation of evidence. I want to highlight that. In the presentation of evidence, where that question is going to be important. So whether we deal with it now or whether we deal with it later during the evidentiary hearings when the cross-examination on this particular issue arises, or whether we deal with it in the final briefing, this is going to be the issue. And I couldn't agree with him more. That's how I started this statement to you. That is fundamentally the issue that this board is going to be faced with once this hearing is over. What impact did the URA have on the EFSA? We are not suggesting, as has been suggested by others, that the URA implicitly or sub silentio overruled some portion of the Facility Siting Act. We don't suggest that at all. The need requirement is there, has always been there through subsequent revisions of the Act over the last 20 years. But the fundamental question, again, that this board will be faced with once all of the evidence is in, and not what the lawyers tell you the evidence is how do you determine whether or not we've proven to you that this facility is needed? That is the fundamental point made by the PUC's advisory opinion, that the URA did in fact accomplish a fundamental shift in how you determine need. And that fundamental shift results from the fact that that act shifted the burden, the cost burden of these facilities from the ratepayers to the developer. And of course, as you know, and again I think this predates Ms. Brady, you in fact denied that, what I'll call prior version of another motion calling into question the PUC opinion. On April 11th, I'll just quote from Ms. Curran, this is from pages 28 to 29, I would move that we deny this motion to the extent that's ever appropriate. It's premature now. What should or shouldn't be the final decision should be addressed at the close of the evidence. Such concerns about the final decision are just not appropriate to be addressed at this time. Whether or not the matters that have been addressed dealing with the appropriateness or the continued appropriateness of the statutory language that has been, as counsel has noted, reviewed by the legislature a number of times since the Restructuring Act, it is just not an issue before us at this time. It certainly should be addressed at the close of the evidence. Certainly concerns about appellate review are not appropriate at this time. That was addressing at that time, what was the threat about appealing an adverse decision by this body. So for all of those reasons, I move that we deny the motion. And that motion was in fact passed unanimously, as you may recall. So you denied the first version of this motion in April, and I would suggest to you that you should deny this version of that motion today. Thank you.
Thank you, Mr. Bleezer. I have a feeling I'm going to have to move the time of that open meeting again. And I want to put people on notice. I know you're going to want to respond.
Yes.
I'm just going to have to keep moving. I'm going to move the time of the open meeting now till 1 and assume that we can have response and still a short break. If I have to move again, I'm sorry, I will. Mr. McElroy.
Thank you. My response is actually going to be relatively brief. The first issue I'd like to respond to is the legal issue of whether or not the advisory opinion constitutes a decision, because if it does, then of course you needed a quorum of 2 commissioners. But that sidesteps the ultimate issue. The ultimate issue is whether or not the issuance of an advisory opinion is the transaction of any business by the PUC. And as I pointed out in my argument, the legislature was clear in drawing up language that would be as broad as possible. The only exception to the transaction of business rule that requires a quorum of 2 is that there is an allowance in the statute for a single commissioner to preside over a hearing. There is no allowance whatsoever for any other activity to be done by a single commissioner. If you look at this board's rule specifically says that advisory opinions are interlocutory decisions. They are not appealable. The statute says they're not appealable. The board's rule says they're not appealable. But that doesn't make them any less of a decision. What my brother would like to say is, well, it can't be appealed, therefore it can't possibly be a decision. You can't walk away from the fact that the statute and the rules specifically say that it is a decision. It is interlocutory, it is unappealable, but it is nevertheless a decision. And under the statute that controls the PUC, a decision can only be issued by a quorum of 2. The second point I'd like to respond to is my brother's argument that he believes that taking administrative notice of the entire PUC record is inconsistent with our motion. I tried to make it very clear when I opened my argument what we were and were not asking for. We are asking for this board, under its statutory authority, to reject the PUC advisory opinion. And only that. As my brother noted, I was the one who suggested that we should take administrative notice of the entire record before the PUC. There's nothing at all inconsistent about taking notice of the entire record before the PUC so that this board can make its own independent determination of the impact and the import of the evidence that was presented before the PUC. The town's position is that the board should look at all the evidence that is available to it. Evidence from the presentation made before the PUC over 2 years ago, and evidence of matters which have occurred since that time to demonstrate that the market has significantly changed, and that these changes in the market that I won't outline again, but I outlined in summary, indicate that there is no longer a need. If there was a need, there is no longer one for the Clear River Energy Center. My brother stated that the sole reason for this motion was the termination of the Unit 1 CSO that is pending review by FERC. I think the arguments that we've made, I think the briefs that we've filed make it clear that that is not the sole reason. Is it a significant reason? Yes, of course it is. As I made clear in my argument, the reasons fall into 2 main buckets. The first bucket is that it's legally invalid for the reasons that we've discussed. That was an argument that I made to the PUC below. I made it both verbally and in writing. As my brother correctly notes, Commissioner DeSimone rejected that argument for the reasons set forth in the advisory opinion. and we respectfully disagree. We believe that his rejection of that argument was an error of law. In order for us to preserve our rights to make that argument on appeal to the Supreme Court, if such an appeal should become necessary, we are obligated to either raise it again before this board or to waive it. We are raising it again. We believe that not only did we have to do that, but that it was the right thing to do, because as the PUC indicated when it handled the matter in the reliability docket, the lack of a quorum renders it incapable of rendering an advisory opinion. I cannot explain why in that docket the PUC did what I believe is the right thing, and in this docket the PUC did what I believe is the wrong thing, except to say that there were different commissioners at the time. And the commissioners who ruled in the reliability docket, or the single commissioner who ruled on the issue and directed counsel to send the entire evidence up to this board with no advisory opinion, was different from Commissioner DeSimone. So you get two different commissioners, you can have two different results. I understand that. But the first result we believe is the correct result and is certainly precedent for the PUC, and I believe is something that should be looked at very carefully when this board decides whether or not it was legally appropriate for Commissioner DeSimone to render an advisory opinion on his own. The issue of the Unit 1 CSO, there is no question that is significant. But I'd like to just restate the fact that Invenergy is trying to have it both ways. My brother stated today, again, in argument to this board, that the Unit 1 termination, quote, is irrelevant to the issue of need, quote. If I've written that correctly, I believe that's what he says. I believe the transcript will support that. He also said that he is supporting and reaffirming everything they said at the PUC docket. That included the statements in the memo and the statements of Mr. Hardy that I read to you in some detail. How can you square my brother's argument today that this Unit 1 CSO termination is irrelevant to the issue of need with just this one sentence from their memorandum that quotes from witness Hardy, who, as my brother Elmer noted, was a joint witness of OER in the Division of Public Utilities. The quote was, if CREC clears in future FCAs and is awarded CSOs, it will be needed. If CREC fails to get a CSO in the future, it will not be needed. How do you square that with my brother's statement that the Unit 1 CSO termination is irrelevant to the issue of need? It's clearly not. When Invenergy had a CSO for Unit 1, it argued strongly that having a CSO was strong evidence of need. Now that Invenergy no longer has, subject to FERC approval, a CSO for Unit 1, Invenergy wants to argue that a CSO is irrelevant in determining the issue of need that this board must determine. The town submits that it's going to be up to the board to determine what the meaning of not having a CSO for either Unit 1 or Unit 2 is on the ultimate issue that must be determined by this board as to whether or not this plant is needed and cost justified. Do you feel the lack of a CSO is irrelevant? Or do you feel that it's strong evidence on the issue of need and cost justification? We believe that it is very strong evidence on the issue of need and cost justification, and the lack of a CSO should lead this board primarily to determine that there is no need for this facility, there is no cost justification for this facility, and to follow the lead of the Connecticut Council that made a similar ruling due to the lack of a CSO. Thank you.
Mr. Elmer.
Thank you, Director Coit. 4 points very briefly. First, CLF agrees with the town of Burrillville that it is not at all inconsistent to argue that briefs and the record from the PUC ought to come here to the EFSB, but the PUC advisory opinion saying we believe the plant is needed should be rejected. All of the evidence ought to come here to the EFSB. Everything that was assembled at the PUC and everything that has come in since then, so that this EFSB can make a sensible, sound, proper determination as to need and cost. Those briefs ought to come in so that this EFSB can see what the parties were arguing earlier and try to square those earlier arguments with what those same parties are saying here. It's just the advisory opinion that asserts, yes, we've looked at it, yes, there's a need. The advisory opinion ought to be rejected as stale, but all of the evidence ought to come in here so that the EFSB can make its determination. Second, Mr. Blazer said that CSOs have been terminated by the ISO in scores of cases. He's confusing apples and kumquats, I guess. We were talking with OER's witness, Dr. Kuhl, here a few weeks ago. There are 350 generators connected to the ISO New England system. 81 or 82 of them are large generators. They terminate their relationships with the ISO all the time. Generally, those terminations come at the initiation of the generator, who files a dynamic delist bid, a static delist bid, a non-price retirement request. And if those requests by a generator to disaffiliate with the ISO get approved under the tariff and then approved by FERC, of course a CSO is terminated. What CLF has said, and is accurate, is that this is the first time in the history of the ISO that the ISO has involuntarily terminated a capacity supply obligation on any generator. And that's true. Invenergy is the first time in the history of the ISO that the ISO has involuntarily terminated a CSO on any generator. Third, Mr. Blazer quoted the January 12th and October hearing transcripts. I gotta say that Jerry Elmer makes a very good impression, those quotes. CLF stands by what I said earlier. There are pluses and minuses to the two different ways of proceeding. You can get your permit first, you can get your CSO first. What we're saying is that the PUC opinion relied so heavily on the presence of a CSO that now that PUC opinion is stale and ought to be rejected. Finally, two things that Mr. Blazer did not say. Remember in the Conan Doyle story, the Sherlock Holmes story, The Hound of the Baskervilles, where Sherlock Holmes solves the mystery by figuring out the dog that didn't bark at the night. It's not what happened, but what didn't happen. Here are two things that Mr. Blazer did not say. Mr. Blazer did not say that the PUC opinion is not stale. PUC relied heavily on the presence of a CSO. The situation has changed. The opinion is stale. And Mr. Blazer did not say that the analysis that I walked you through from Mr. Hardy's testimony about the cost benefits of this putative hoped-for plant, the cost benefits came mainly from the capacity side of the market, not from the energy side, and those cost benefits to ratepayers largely disappeared when the CSO disappeared on September 20th. Thank you.
Mr. Blazer?
Very briefly. We've been at this far longer than we all expected when we scheduled an hour. All right, I've been writing furiously. I do apologize. Mr. McElroy said, these are going to be not necessarily connected to each other. I'm just reading, this is stream of consciousness, so I do apologize. Mr. McElroy said our position is, this is with respect to the single commissioner issue, that our position is that it can't be a decision because it can't be appealed. And then he said, but it is a decision. With all due respect, and everybody knows I respect him greatly, again, 4298-10B very expressly says, no, it's not a decision. Advisory opinions issued by agencies designated under 4298-9 shall not be considered as final decisions of the agencies making the opinions. Period. But you know what? You finally heard what I think the lawyers all recognize is the real reason why he's making this motion now. 2 years after the same argument was rejected by the PUC, he wants to preserve it for appeal. So be it, it's preserved. The point I had made about our agreement regarding the PUC record and the fact that it's inconsistent with the position being taken that you should reject the advisory opinion. You know, it's interesting. Both lawyers have now doubled down on the assertion that the entire PUC record is relevant and should be considered by this board. And we agree. Where we disagree is the one thing they don't like, which they don't want you to consider, is the ultimate result of that record, which is the advisory opinion that they don't like. Mr. McElroy also said that he agreed that potential termination of our CSO is a major, but he says not the only reason for this motion. And he continues to talk about changed circumstances. Well, we addressed those changed circumstances to the extent they exist by agreement on September 14, when we all filed supplemental testimony on the issue of need. This motion wasn't made then. So you have that in the record. And again, this board recognized when we all agreed that supplemental testimony on need should be filed, that the proper way that this needs to be handled is you hear the evidence from the witnesses, again, not the lawyers, on whether or not need has been proven. You'll then get post-hearing briefs, and the principal issue will be, what did the URA do to the issue of need? And then you're going to have a tough decision to make. And then I almost wasn't going to do this, but when he said apples to kumquats, I just can't help myself. This is from January 23rd, 2018, a submittal to the Federal Energy Regulatory Commission from ISO New England pursuant to Section 205 of the Federal Power Act, just as the submission that was made by ISO with respect to our Unit 1. Accordingly, by this filing, the ISO is exercising its right to terminate a portion of the resource's CSO. So, with all due respect to Mr. Elmer, it's apples to apples, not apples to kumquats or any other fruit. That's all I have. Thank you.
The third motion is the Town of Burrillville's motion to reject the PUC advisory opinion. And we heard the arguments first made in the first motion, and then the town had a supplemental motion. So I wanted to make a few comments. This is the one where we have disagreement, and see what you think, and then I would be prepared to make a motion on that. So first, things have changed a lot in the last 3 years and in the last 2 years since we've had the advisory opinion from the PUC. And some of you were here in March of 2017 when I voted to approve asking the PUC to do a supplemental advisory opinion, and that got voted, that did not carry the day. But that was over 18 months ago when I was concerned that I wanted to hear whether things that had changed were relevant to the ultimate conclusion. So from my perspective, first, it's not untimely. Things have changed considerably. Second, I don't think it's inconsistent to take administrative notice of what's in there and then reject the conclusions, because I think that the factors on which the conclusions were based, some are the same and some have changed, but we'll never know whether the PUC at that time would have come out differently had they known the factors that have changed. And I think it's fair to all of the parties, including the applicant upon who has the burden to show cost, to show need, and to answer the questions regarding cost, that we actually make an independent conclusion on that. I know that by taking administrative notice, we have everything, all the arguments that were made and the evidence that was made, or the evidence that was presented. But for this board to make a sound decision on those key elements now, I believe we need to hear that evidence, consider what's changed, including the many factors that have changed, including quite recently. So I feel the right thing to do is to reject the PUC's advisory opinion. I'll note that you've all cited the provision of the Energy Facility Siting Act that says we can reject, approve, or modify an advisory opinion. So no one feels that we don't have the authority to reject an advisory opinion. Normally, we would do that in our final decision. But again, I'll just say, I want you all to know that I'm rejecting it as the conclusions now, because I feel that you need to present updated evidence to make that case. So that's my opinion, and I'd love to discuss it or hear what you have.
Maybe you should make a motion for discussion.
Oh.
And then you could second for discussion.
All right, I will move to approve the motion by the town to reject the advisory opinion of the PUC. Discussion.
I will second that motion for discussion. Thank you, Chairwoman. I appreciate the opportunity to speak on this. As was pointed out by at least two of the parties, in this initial part of the case, I was not present here. But having read through much of the file at this point, and having read the transcripts of the proceedings that have taken place that we have referenced today, I do feel that it is an accurate statement to say that the information that's in the advisory opinion of the PUC is stale at this point, and that we really do need to see some refreshed facts and have the opportunity to make a decision ultimately based on the best knowledge possible, which I don't believe is before us now in this opinion. So I would actually concur with the statements that you made and with your opinion that we should in fact approve the motion and reject the advisory opinion, and that we have the authority to do so based frankly only on the authorities and powers given to us as the Energy Facility Siting Board.
Well, then let's vote on that motion, and then I think I want to have a little bit of back and forth on how that affects our schedule. So I'm not always that. We moved it for discussion. Now I will just again make a motion to approve.
You could call for a vote.
Okay. So discussion. No further discussion, then a vote on my motion to approve the town's motion to reject the PUC advisory opinion. All in favor? Aye. Aye.